Hey, Eric here. Welcome to my small channel, a channel that I've dedicated to talking about and exposing lazy, poorly trained, corrupt government officials and public servants and idiotic, tyrannical law enforcement officers. In today's video, I'm going to be talking about a current sitting assistant judge in Grand Isle County that is running for the Vermont House of Representatives, and it appears she is doing so in direct violation of the Vermont Code of Judicial Conduct. Her name is Josie Henry. She's still actively serving as an assistant judge, and she hates free speech. She'll stop at nothing to silence any critic, especially me. So last week, I saw a post on Facebook that was put up by Republican Representative Michael Morgan. So he announced on his personal Facebook page that she is his running mate. In that post, he described her as a, quote, former Alburgh Select Board member / chair, a Grand Isle County side judge, and a retired Navy officer, end quote. That wording is very misleading. By using the word former on the first title and retired on the last, it strongly implies that she no longer holds any of those positions, when in fact she is currently a sitting assistant. According to Canon 4, Rule 4.1 of the Vermont Code of Judicial Conduct, a judge must resign their judicial office when they become a candidate for any other elective office. There are limited exceptions, and running for the House is not one of them. The House Judicial Ethics Committee even reinforced this in Ethics Opinion 2728-3. Just months ago, on February 2nd, 2026, Rutland County Assistant Judge David Wolk resigned his position because he wanted to run for state senate. He followed the rules. Now here's some important background. Josie Henry was previously chair of the Alburgh Select Board. While in that role, she helped create the town administrator position. She later left the select board and became an assistant judge, and then took on the town administrator job that she created, wearing multiple official hats at the same time. Maintaining that town administrator position as a sitting judge was a violation of the Code of Judicial Conduct. However, she relied on a memorandum from the Vermont Judicial Ethics Committee to justify keeping the job, even though that memorandum did not clearly apply to her specific situation. So how did we get here? Let's take a walk through this timeline. It started on May 13th, 2025. Josie Henry, while serving as town administrator, appeared before the Vermont House Government Operations Committee, along with Select Board member Jim Hokenberg. The testimony they gave, which was false and misleading, was actually ghostwritten by Select Board member Alex McCracken. Alex drafted the document together with Josie Henry, but he couldn't deliver the testimony himself because he wasn't even a Select Board member at the time of the incidents that he was writing about. So Jim Hokenberg read it instead. 2 weeks later, on May 28th, Josie stood before the Alburgh Select Board and asked them to create new policies to silence me on the official Town of Alburgh Facebook page for criticizing her and other town officials.
I have a comment.
Yeah.
I have a request for you guys. This is the request to remove the defamatory content from the Town of Alburgh Facebook page. Dear members of the Alburgh Select Board, I'm writing to formally raise concern and request immediate action regarding a public post recently published on the official town homepage. The content in question includes several false and damaging claims that harm my reputation and call into question the integrity of the position I fill. Specifically, the post falsely claims that I have obstructed access to public records, I'm unlawfully serving without required oaths or bonds, which all of you know a town administrator doesn't take an oath or bond. I have violated ethics duties in my role as assistant judge. I'm involved in a criminal conspiracy under federal law. I misled the Vermont legislature. These statements are factually incorrect, misleading, and harmful. The post also includes legal references that are taken out of context or misapplied. Posting such content on official town communication channels lends it unwarranted legitimacy and creates the appearance of town endorsement. I respectfully request the Select Board take the following steps without delay. Remove the post and associated comments. Adopt a social media policy to safeguard town employees from such attacks going forward. And publish this statement in the minutes along with a statement of apology. I'm raising this issue not only to protect my own personal reputation, but also to ensure that the town's official communication platforms are used responsibly and in accordance with public trust. Thank you for your consideration. I remain committed to working collaboratively and transparently in service to the residents of Albert. I'll give you this to consider.
I posted on that official page May 25th of 2025 and June 2nd. After she lobbied to have them removed, both posts were taken down. I was also blocked from the page, and I remain blocked to this day. I've reached out to multiple town officials, the page administrators, including the town clerk, Danelle Chenure, asking to be unblocked because I was blocked for viewpoint discrimination. I've received no response. When I learned about the testimony given to the legislature, I immediately sent a formal letter to the House committee, including Representative Michael Morgan, demanding a sworn fact-finding session so I could present evidence and rebut what was said about me. They completely ignored me. The legislature then went ahead and broadened the disorderly conduct laws. Meanwhile, the Alberg Select Board ended her tenure as town administrator.
How you doing, Mr. Oakenberg?
Yes, I have a statement here to read. Good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to testify today regarding a troubling and potentially dangerous situation facing the Alberg Select Board. I understand that the bill before you today, Act 59, would contain several amendments to Vermont's current open meeting laws. As my testimony will illustrate, there is a need to amend the current statute to ensure the proper balance between public transparency and the ability for local officials like myself to do our work. First thing, I'd like to provide the committee with some background on an issue currently facing our board. I know that we are not the only municipality, obviously, with similar stories. In December 2023, two individuals from a neighboring town were placed on the Alberg Select Board agenda. After requesting time to address the board about a complaint regarding the county sheriff, during the board's first interaction with them, these individuals were rude and unreasonably combative. In January 2024, these two individuals attended a select board meeting demanding to discuss their complaint. Board members informed them that this meeting was a special meeting for budget planning and that they were welcome to listen in, but had to stop interrupting board members and demanding answers to topics not on the agenda. Eventually, they departed that meeting. At the next regular board meeting in January 2024, the two individuals returned. One of them was video recording the board meeting with their phone, invading the personal space of board members to record them uncomfortably close. He interrupted the board chair with continuous questions and began raising his voice about how his rights were being violated. The board chair attempted to maintain order by referring to the meeting rules and procedures, but efforts were unsuccessful. Eventually, the town administrator and one select board member escorted them out of the meeting room. The two individuals argued and yelled at the town administrator and selectmen until eventually agreeing to leave. Members of the board, members of the public expressed they were frightened by their harassment and attempts at intimidation. The board did not hear from them again for over a year. Recently, one of these individuals began engaging the town clerk and town administrator with official record requests, personally centered on the former chair of the select board, who now serves as the town administrator. The tone of these requests has been rude, threatening, unprofessional, and accusatory. This email correspondence has been above and beyond a reasonable amount. Within the past 11 days, our town clerk has received over 34 emails requesting various records. This presents an inordinate burden on our limited town office staff. The town office staff is overwhelmed and stated these requests are interfering with normal duties. The individual has stated he will be appearing at an upcoming select board meeting, and the board is struggling with how to ensure the safety of its members, other town officials, and the public while adhering to the state statutes. We are engaged with our attorney, but there is little we can do other than answer the request and brace for another chaotic and potentially dangerous meeting until legal changes are made. We recognize the importance of transparency and accountability in local government. However, there is a fine line between being a gadfly, which supports the public interest by promoting transparent practices, and being a burden to public resources for personal vindication. These interactions are wholly outside of the public good and take valuable time, resources, and energy away from pressing matters that our constituents need us to focus on. And thank you again for this opportunity to read you this and testify. I look forward to your questions.
No, thank you very much, Jim. First, I'm sorry this is going on in your area of the state for the board and for the staff and the municipal employees. First thing, the statement that you read to us, could you or someone email that to us so we could have it on record?
Yes.
Thank you. And how much staff does that office have?
We have the board, select board, we have our town administrator, we have our town clerk, and we have an assistant town clerk.
Okay, so the board, about three employees?
Yeah.
So I'm going to ask kind of the same questions I was asking before. Do you folks have an idea of what the legal cost burden has been for the municipality while trying to navigate this stuff?
I don't have a figure on that. Josie, do you?
This is Josie Henry, the town administrator. Is it okay if I chime in?
Oh, please do. Hi, how are you?
Hi, great. How are you?
Not bad, not bad.
So as far as legal costs, we have tried to avoid involving the attorney until we really needed to. So we're just getting started on this round. The last time things happened in January of 24, we didn't get the attorney involved. But I can say, because I'm also a county official, that this same individual has been engaging in these techniques at the county level, and we've spent thousands of dollars at the county level to date dealing with the legal issues.
Right. And then I guess sort of how many staff hours do you think this is occupying on a week-over-week basis?
I would say it's about the same as the other gentleman spoke, 5 to 10 hours a week.
Yeah.
Okay. And the disturbances at the county level, so at the county courthouse, I assume?
Yes, the courthouse. I'm the county, I'm assistant judge, so county administrator, and also sit as a site judge.
Oh, okay. Well, thank you for doing all those. So is it the same sort of engagement that with the individual is just the disruptive nature of records requests? Is it paralleling at the county level to what you're experiencing at the municipal level, or is the contact Not the same.
The records requests have been voluminous at the county level and culminated with a federal suit being filed against Sheriff Ray Allen, myself, and the county clerk, Susan Bohanna. So we're not sure at this point where that litigation will go. And so those legal costs I mentioned earlier could end up being a lot higher. But once it did start in the same way that this one is, with many records requests and then accusing us of, as someone else mentioned from their town, not following the days required or responding fast enough, and then filing a lawsuit.
And then the federal situation, what is, you said a lawsuit at the federal level as well?
Yeah, we haven't been served, as in myself personally or the county clerk, but I believe Ray Allen was our sheriff, and we're waiting now to hear next steps on that.
Brett Morgan?
Hey, Josie. Hi, Jim. Thanks for coming in and testifying. Have you all ever had to have Ray Allen actually come up and physically remove anybody? Have you ever requested that? Has that ever had to been done, or state police, or any law enforcement involvement directly?
No, we haven't actually had to have a sheriff here. We have spoken to Ray about possibly having sheriffs in the area in case they're needed.
Mm-hmm. Okay.
And we did contemplate having him at the January 2024 meeting, but the issue at that time was somewhat tied to the sheriff, and it was a complaint about the sheriff, where, again, as another person testified earlier, we felt they were disrupting us to get us to call them so they could file, get in some sort of altercation with the sheriff's department. So I think had that not been going on, we would have had him at that meeting.
Yes.
Okay. All right. Thank you.
I'm just trying to think if I have anything left to ask.
Commonality.
Yeah, no, it's very similar.
Same stories are resonating throughout.
I guess my last question for you folks is, what do you feel would be helpful to see as a legislative possibility to help mitigate the issues that you folks are having?
I've thought through this, and I'm very aware of First Amendment rights, and it's a really difficult dilemma. But if we were able to say someone who violated the procedures of our own board on multiple occasions and could then mandate they attend virtually, not in person, I thought that might be a way to get at this. I don't know what your thoughts are on that.
That would work.
Okay. No, thank you for that. I appreciate it. And if you don't mind sticking around for a second, just in case we have a couple of questions, I kind of want to see if the committee had any questions for council right now. And then I also wanted to entertain just being aware of the calendar and our desire to get this bill dialed in, hopefully by the end of the week, to vote out what people's thoughts were on how to.
I previously filed a federal suit naming Josie as one of the defendants for these First Amendment violations. That case relies on the 2019 Fourth Circuit ruling in Davis v. Randall. Judge Crawford ruled that the Town of Alberg's Facebook page was an official page. However, he dismissed Jim Hokenberg and Alex McCracken, saying that even if their testimony was false and the law was changed because of it, that there was no sufficient nexus that showed their actions chilled my free speech. As an assistant judge, Josie Henry has also played a role in blocking my access to the Grand Isle County Clerk's office for the last 2 years. I've been trying to review whether the sheriff's oaths and bonds are properly registered with the county and to learn more about statutory compliance surrounding these documents. Despite being repeatedly denied direct access to the county clerk, Susan Bohannon, she was dismissed from the federal case. Josie Henry's personal attorney improperly got involved, falsely claiming to be the head of agency under 1 VSA 318 for exhaustion of administrative remedy purposes. Most recently, just last Tuesday, when I went to the county clerk's office, they tried to hand me documents through the security guard, who is not a county employee and has no authority to facilitate public records requests, claiming Susan was at a funeral and the office was closed. I was unable to take the documents and explain I am attempting to talk to Susan for a story I'm covering. I followed that up by emailing Susan. I'm here today because I've been trying to get into this county clerk's office since October of 2024. The objective of getting in this office is so that I could review the sheriff's oaths and bonds after an incident that happened with his deputy sons. Talk about nepotism, right? However, I was denied access by Susan Bohannon, the county clerk, and then followed with obstruction by Josie Henry, which led into the civil suit. And most recently, the judge made a decision and removed Susan from the suit. However, I still could pursue her in state court for public records access. But why I'm here today is after finally getting confirmation from the county's lawyer, well, Josie Henry's lawyer, because she's being sued in her individual capacity, I learned the county's open hours of operation. So I'm here today to ask pointed questions of Susan Bohannon about the proper ways to file oaths and bonds for statutory compliance. Let's see how this goes.
Oaths of enlistment or something, but they left me some paperwork here.
So, what was that?
They left me some oaths, some paperwork here. They said that you were asking for to review.
I'm here to speak to Susan Bohannon.
Okay.
She's supposed to speak to me.
Right. So I got this morning, sitting here on the desk when I walked in. It's a letter.
So this says right here, it says, if anyone asks, the county office is closed today to attend a funeral, i.e. Susan's office. Thank you. However, if anyone wants to see the oaths of office, there is a stack of files. What's that, on Susan's shelf?
Yeah, but
readily available for review.
They're actually here.
So you see what I'm saying? Okay. Perfect. I'm not gonna take those because I'm gonna come back.
Okay.
I need to talk to Susan. I have a lot of questions I need to ask of her.
Okay.
Yeah.
Fair enough. Yep.
Thank you.
Yep.
So I, in good faith, cannot take those oaths of office from you because you don't work for the state.
Right.
You're not employed of the county.
Right.
That's Susan. That's not your job. Susan knows I'm trying to speak to her. I'm trying to speak to her directly.
Okay.
This has been going on since October of 2024. So I'm sorry they put that on you. I'm not surprised though. Then, another assistant judge for the county, Sherry Potvin, began emailing me from Susan's account telling me that now I cannot enter the clerk's office, claiming that it is a secured location of the building and I must submit records requests in advance, something I've already done. Anyway, not once since October of 2024 when I began to try to access this office was I ever told this. She is now impeding my access to the county clerk after providing the open hours of operation, denying me access to the county clerk herself, and the opportunity to ask her pointed questions necessary to better understand the process so that I can disseminate the information to the public. By the way, this is the same county where State's Attorney Doug DeSabato was recently cited for DUI. I covered that in one of my recent videos. He drove to a neighboring courthouse and there he was taken in custody for suspicion of DUI. He later produced a BAC of .084, admitted to popping 2 prescribed Xanax. He's the type of tyrannical piece of shit that would enforce laws for vehicle immobilization and asset forfeiture for the same type of crimes. Despite all this, Republican Representative Michael Morgan posted on his personal Facebook page announcing Josie Henry as his running mate. I found this suspect since Josie Henry testified before the House Government Operations Committee with Michael Morgan sitting as a member. And roughly 1 year later, he chose her as a running mate. This is pretty huge and suspicious leap. Additionally, I recall Josie being registered as a Democrat before the announcement, but is now registered as a Republican. I don't know. They do whatever. Anyway, I left a detailed comment explaining this entire history on his page, and he deleted it. I left it again, he deleted it. I posted the same thing from a second account, and he deleted that one too. Clearly, Republican Michael Morgan hates free speech as well, and will delete and block dissenting opinions and voices. However, here's an important distinction between Josie Henry, what she did, and what Representative Michael Morgan did on the Facebook censorship. Josie Henry had my post removed from the town's official Facebook page, which clearly falls under Davison v. Randall, precedent as government speech. However, Republican Representative Michael Morgan deleted my comments on what appears to be his personal page during his re-election campaign. In 2024, the U.S. Supreme Court raised the bar in Linkey v. Freed, making it much harder to prove First Amendment violations on personal pages for public servants and government officials using social media. Imagine my shock with that. I've sent numerous emails to both Republican Representative Michael Morgan, Assistant Judge Sherry Potvin about these canon law violations, trying to warn Michael Morgan and the public about the kind of person he's chosen for a running mate. Those emails have completely fallen on deaf ears. It's becoming ever more clear that Josie Henry is anti-First Amendment and is looking more and more like Republican Representative Michael Morgan isn't much of a proponent of free speech either, nor is he truly interested in accountability and transparency. People need to know what these individuals truly stand for. If we allow them to trample our rights while holding the purse strings to our tax dollars, they will slowly erode our freedoms and rob our pockets. Not for the good of the people, but for their own personal gain. These grifters have no place in local or state government. The people of Grand Isle County, Chittenden County, and Vermont deserve far better, but not enough people actually seem to care.